Hey guys, how's it going? So, I have a bit of good news for you actually today. And this is that a military appeals court has just ruled that the bump stock is not a machine gun. So, let's check this out. And I'm going to bring you over to this article on Ammo Land, and this was written by my friend John Crump. So, definitely give him credit and make sure you go check his YouTube channel out. So it says the United States Navy Marine Corps Court of Criminal Appeals has ruled the bump stocks are not machine guns in the United States v. Ali Alcazag. Marine Corps Private Ali Alcazag was convicted of possessing two machine guns in violation of Articles 83, 107, and 134 of the UCMJ. These machine guns that they were charging him with and that he possessed were actually bump stocks. Now, the Private's Defense Counsel immediately argued that bump stocks don't meet the federal definition of machine guns. And I'm going to show the court ruling is going to be embedded in this article, which I'm definitely going to leave a link to down in the description. And you guys should read this whole ruling because this is a really good ruling. And although many of us watching are not currently in the military, and this court might not have jurisdiction over us specifically, this is actually a win because it's building lots of positive momentum in our direction. So, a three-judge panel agreed with the defense unanimously ruling that bump stocks do not meet the definition of a machine gun. So it goes on to explain that these three judges actually laid out a case that anti-gun activists put political pressure on Congress after the murder in Las Vegas where 60 people died. And if you guys remember, there was a bill that was put forth in Congress at that time, and it was called Closing the Bump Stock Loophole. You can't get much more politically charged with a name of a bill like that. However, both chambers of Congress failed to pass that. It never passed the Senate. It never passed the House. So, in the absence of a law that would classify bump stocks as machine guns or ban them, which is, in my opinion, how laws should be made, and that's actually what the Constitution says too, they put political pressure on Trump. And I remember when it happened, and a lot of us do. This was not a good thing at all. And Trump basically said, I'm looking into banning bump stocks. He said, I don't like them. I want to get rid of them. I think a lot of you guys remember him saying stuff like that. So, Trump ended up ordering the ATF at that time to ban bump stocks. And they did. Now, the three-judge panel notes that the president did not have the authority to make de facto law. The judges wrote, and this is a quote, instead, the president directed the BATFE to issue new interpretation of a rule that contradicted the ATF's previous interpretation, governing legislation from the 1930s. This executive branch change in statutory interpretation aimed to outlaw bump stocks prospectively without a change in existing statutes. And this is what a lot of us have been saying, and what the GOA is currently arguing. They're arguing that along with the next part of this. First, they're saying, look, this doesn't meet the statute of a machine gun. And if you've ever read the National Firearms Act, pretty obvious that bump stocks do not meet the statutory definition. But they're going to go back over some history here, and then they're going to touch on the Chevron deference. And by the time I'm done here, you're going to see where this ties right in with what's going on right now in the U.S. 6th Circuit Court of Appeals, where the GOA is going to start making their oral arguments in front of the en banc panel on October 20th this year. This is coming really fast in about a month. So these judges, they didn't just write like a quick rule. This is a very, very in-depth, elaborate court decision. And here's how this normally works. When other courts are looking at court decisions, the better the argument is, the more thorough it is, the more it is actually looked upon by potentially other districts, and in this case, hopefully, the Supreme Court, because I hope that the GOA is victorious in the U.S. 6th Circuit, that case that's coming up real soon, right now. Hopefully Supreme Court's going to look at this, and we'll also be taking this military three-judge panel's decision into account. Now, these judges actually looked in the whole history of the bump stocks and how the ATF had flip-flopped several times on this, going all the way back to this Atkins accelerator, which was a device that originally was approved by the ATF. Then they reversed that approval in 2006 and said it was a machine gun. Now, the reason why they said it was, this was the ATF, and this whole Atkins accelerator was part of what the ATF used in their arguments to ban the bump stock. So this has to do with what we're talking about with the bump stock ban, Chevron deference, all this stuff is like super tied in. So this Adkins accelerator, the government argued, the ATF said, hold on, this uses a spring, and since it uses a spring to actuate this rapid fire, that makes it a machine gun because of the physical mechanism. However, the bump stock doesn't use a spring, and it's the polar opposite of what the ATF had previously said with that, kind of pointing out the obvious hypocrisy. And the judges noted all that. It says, Mr. Atkins filed for a summary judgment in district court and lost. The judges in the case stated that a single function of the trigger means a single pull of the trigger. Since the Atkins accelerator used a spring, it was a machine gun. If the accelerator didn't have a spring, it would have not been considered a machine gun. While bump stocks obviously use recoil, there is no spring. You're actually, each shot is firing with a single pull of the trigger. Now, not only do the judges note that and all the history and the inconsistencies and flip-flopping of the ATF, but they also call out Chevron deference. And this is huge, guys. For those of you that are still watching that are saying, but I don't have a bump stock. You don't like bump stocks. Look, I'm not going to tell you what you should like, although I hope we should all agree that shall not be infringed means they can't ban any of these things. But I digress. This is called Chevron deference in conjunction with the bump stock. This is the beginning of that slippery slope that I've been warning about on my channel ever since Trump proposed the bump stock rule. And this Chevron deference, the fact that the government and the ATF are now saying they can use this for criminal cases such as bump stocks. They're using that to have so-called authority to do things like reclassify arm braces, stabilizing braces into SBRs. And the comments just ended on that yesterday. Now, recently, a couple weeks ago, the comment period just ended on reclassification of frames and receivers, where they want to have serialized and background checks done on like 10, 20, 30, sometimes 40 parts, depending on what the gun is. And here's where this is big time right here. The judges also pointed out the classification of bump stocks as machine guns relied on the Chevron deference. The panel points out that the courts have not settled if the ATF can use Chevron deference to make bump stocks machine guns. They pointed out the GOA's case and the Sixth Circuit Court of Appeals. That's the one I've been talking about. And also cited other instances where courts say the government cannot use Chevron deference for a criminal statute. So, I did some research, guys. I'm not an expert on the way military courts work, me being a lifelong civilian. I'm pretty certain that this ruling on this 3-judge panel is obviously favorable to this private that particularly was criminally charged. I don't know what ramifications this holds over people who are currently in the military. From what I understand, there is an en banc panel that the government can appeal to, similar to how the Sixth Circuit works. So this may not yet be the end of the road for the Navy Marine court process, but this is certainly headed in the right direction. And obviously, since this military appeals court was citing the Sixth Circuit, hopefully the Sixth Circuit will also look at this military court, appellate court's ruling. Very strongly worded ruling, very comprehensive ruling, and these are the types of opinions that higher courts actually look at. And in this case, I'm trying to be optimistic. Let's hope that the Sixth Circuit, that there's a victory with this en banc panel. Then the only place left is the Supreme Court, and hopefully this will be yet another lower court case precedence that hopefully the Supreme Court can look at and help get rid of this. Not only the bump stock ban, guys, because like I'm going to say one more time, it's so much bigger than that. No, getting rid of the ATF's ability to use this Chevron deference, where it says that if there's any ambiguity in a law, that the agency's interpretation of said law holds precedent and that courts aren't supposed to be able to go against it. That's what Chevron deference does, and that's what the ATF's relying on with, you know, all these things that are going on lately where it just appears they've gone totally rogue. I mean, we've got rare breed triggers, bump stocks, reclassifications of frames and receivers, braces. All of this stuff is contingent upon this bump stock case and whether Chevron deference can be applied to criminal cases. So this is actually a pretty good victory. Although it's in the military court system, this is still a very, very high-ranking court. And it's not exactly a parallel, but it's going to be similar to how, like, the Sixth Circuit, the different circuit courts of appeals, this is the equivalency of that, but in the military. And no doubt, other courts are going to be taking notice of what this 3-judge panel said, and that was a unanimous decision that bump stocks are not machine guns, both not by definition. They're also not machine guns by the same prior interpretations of the ATF. And this 3-judge military court also said that they're not convinced that you can use the Chevron deference for criminal cases. So we've still got a lot of fighting to go on this topic, guys. But today was a victory, and I'm kind of encouraged by it. All right, thanks for watching, and have a good one.